Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. A warm welcome to all the new subscribers. I am so happy to have you here. And to our dedicated listeners, thank you so much for your loyalty. This episode is a continuing series on the trial readings for the Darlie Routier case, a mother who in 1996 was accused and convicted of murdering two of her children in Rowlett, Texas, and who currently sits on death row. As soon as these trial readings are all finished, I'll be back to doing weekly true crime and paranormal cases. Now, in the last couple of episodes, we've heard testimony from Darlie Routier. We've been hearing testimony from the defense witnesses. And his testimony is actually not finished. We just finished up with his testimony number 2. There is still one more to go with Darren. But the thing is that if you remember, back when it wasn't too long ago, just a few episodes ago, that we heard from Detective Patterson. And Detective Patterson, they got into questioning about the microphone at the gravesite. And before he would answer any questions about that, he had to consult either with an attorney or go read up on some federal and state statutes and rules regarding the legality of that. And so he was let off of the stand to go do what he had to do. And then there were a few more witnesses, and now we had Darren a couple of times, and then now we're back to hearing the rest of Detective Patterson's testimony, but we're also going to hear from Detective Frosch as well. I will have the links to Patterson's previous testimonies in the show notes below, so if you want to listen to those, I will make them available for you. And Frosch has actually not been on the stand yet, so this is a new testimony for him. With all of that said, let's go ahead and begin with the testimony, again, of Detective Patterson. And the entire proceedings begin like this. The court says, "Mr. Mosty, are you ready?" Mr. Mosty says, "Well, that depends on what we're getting ready to do." The court says, "Well, all right. Where is Mr. Mulder?" And Mr. Mosty says, "I don't know, Your Honor." And the court says, "All right. Let the record reflect that these proceedings are being held outside the presence of the jury and all parties in the trial are present. Mr. Mosty, you will be representing Mrs. Routier for this hearing. It's past 8:30, and I have told everyone to be here at 8:30. Mr. Mosty says, "Yes, sir, I will represent Mrs. Routier." The court says, "I figured that is what we will do." Mr. Mosty then says, "If that is okay with the court." The court says, "That is fine with the court, fine with the court." All right. The purpose of this hearing today is we're discussing the microphones that were put out at the cemetery. And officer, let the record reflect that Officer Patterson is present and he has been appointed an attorney for this purpose. Mr. Albert Patillo from Kerrville, and Officer Frosch has been appointed Mr. Steve Pickle, Pickell, of Kerrville. And Mr. Patillo, you have conferred with your client? And Mr. Patillo says, "Yes, I have, Your Honor." The court says, "And what is the result of that conference?" Mr. Patillo says, "We will decline to testify further in this matter, and my client, on my advice, will take the fifth." The court says, "As regards to the microphones at the cemetery?" Mr. Patillo says, "Yes, sir." The court says, "All right. Will you have Mr. Pickle and his client step in, please, and let the record reflect that Officer Frosch," and I am embarrassed, I have forgotten your first name. Officer Frosch says, "Chris." The court says, "Officer Chris Frosch, Frosch, is present with his attorney, Mr. Steve Pickle. And have you conferred with your client, Mr. Pickle?" "Yes, Your Honor." "Okay, what is the result of that conference?" "Your Honor, Detective Frosch would assert his Fifth Amendment right." The court says, "Concerning the testimony as regards to the recording devices or the microphones or whatever that were put up at the cemetery, and only regards that, concerning only that portion. Is that correct?" Mr. Pickle says, "That is correct, Your Honor." The court says, "All right, fine. Anything, Mr. Davis? Mr. Greg Davis of the prosecution says, yes, sir. At this time, the state would indicate that we believe this testimony is not relevant. It's improper impeachment. And again, I'm talking about the subject of the mic on the gravesite. And we would ask that the court instruct Mr. Mulder not to go into these matters any further in front of this jury, because again, we feel the prejudicial effect here of having to inform the jury that these officers have taken the Fifth Amendment. Again, we believe that the matters are irrelevant and that they are improper impeachment. The court says, the state is not going to use anything that came out of that. Mr. Greg Davis says, that is correct. We are not going to go into that matter. We are not going to offer any of those recordings, video or otherwise. So we did not intend to talk about that matter in front of this jury. The court says, was there any exculpatory material in that? Mr. Davis says, no, sir. But in caution, I did turn over those matters to the defense. The court says, so the defense has those tapes? You gentlemen have those tapes? Mr. Mulder says, Judge, they are the ones that first went into this matter. We didn't go into anything at the gravesite. They did. The court says, all I want to know right now, Mr. Mulder, is, do you have those tapes? Mr. Mulder says, well, I have some tapes. I don't know whether I have those. The court says, did you listen to them? Mr. Mulder says, yes, sir. The court says, when were they given to the defense? Mr. Mulder says, well, we didn't get into the case until Mr. Greg Davis then says, probably sometime in November, I believe. Mr. Mulder says, so if it's like everything else, it came in at the last minute or sometime in January. Mr. Mosty, also of the defense, says, well, let me describe that, Your Honor. There is a videotape that is obviously taken from a vehicle near the gravesite that you can see it panning on various people, and then you hear the audio. Sometimes the audio, it depends on how close they were to the mic or whether or not you could hear it. But that video it starts off with some gentleman out there watering the gravesites, apparently an employee, and I am guessing, it covers maybe as much as 14 hours that day. The court then says, well, then the video does, and Mr. Mosty interrupts the judge and says, so it's hard to say. And our copy, I don't know what the state's copy is like. Our copy is not all so great on the video part. Mr. Mulder of the defense also says, Judge, I would like to point out to the court that I think felonious conduct on the part of the police officers during an investigation is always material. It goes to the integrity of the investigation. And whether they like it or not, they are the ones that opened this up. We didn't go into anything at the gravesite. The prosecution did. And, they have to take the bad with the good. They were smiling and telling jokes when this video was on for the jury. And now they have got to take the corresponding responsibility of what this has brought. So, anytime the investigation has been compromised by felonious conduct on the part of the officers, it's always admissible to the jury. And I would certainly caution the court or remind the court that they can't take the fifth on part of their testimony. They are like everybody else when it comes to getting on the witness stand. They can't assert the fifth just to a certain matter and say, quote, I don't want to talk about that and I want to hide behind the Fifth Amendment. Mr. Mosty then says, and not only the relevance issue, the court has got to remember that Cron has testified that he decided within 20 minutes of the defendant's guilt, that the Rowlett Police Department was informed of that Mr. Davis was on the job within 5 days after that, and that this whole focus, as I said in my opening statement, she became the target in the rifle scope at the beginning, and the methodology and how the Rowlett went about investigating this and choosing not to investigate other things is directly shown by going out and putting an illegal bug out in a graveyard. The court says, okay, so you're using this to impeach the officers. Is that correct? Mr. Mosty says, I don't know that impeach is the right. And then Mr. Mulder says, not exclusively. Mr. Mosty says, we're using it to show what they did. It's just a simple fact of how they investigated it. Mr. Mulder says, but Judge, once again, they brought it up. We didn't go into this matter, and now they have got to take the bad with the good. The court says, let Mr. Hagler make his objections. These are the real objections. Mr. John Hagler, also of the defense team, says, well, Your Honor, a couple of things as far as the facts. They are arguing irrelevancy, Your Honor. Again, I think Mr. Mosty has already stated that certainly it's relevant in the fact that the defendant was targeted in this case within 20 minutes as being the assailant. And certainly this would have some relevancy as to the jury in our showing that there is a motive on the part of the police department to actively pursue the defendant and to target her as the assailant in this case. Secondly, Your Honor, they, of course, have offered the tape. They made the issue of the gravesite matter in this case. They have injected this matter in front of the jury. Certainly, we're entitled to bring out all of these circumstances surrounding the gravesite matters, Furthermore, is the fact that they have made the issue of lack of remorse at the gravesite an issue. And we're entitled to elicit all of the testimony from these officers. I might mention they're talking about tapes and the video. Now, to my understanding, and I don't know all of the facts, obviously, but there was an open wire on this gravesite. There may well be matters other than that which appear on the tape and on the video surveillance. Of course, the tape is the intercept problem we have here, but we don't know what all transpired out there. We don't know who was privy and overheard all of these oral conversations. As I understand it, if the court denies us an opportunity to confront and cross-examine these witnesses, we're denied the opportunity of eliciting all the facts and testimony surrounding the gravesite event and incidents. And I would further submit to the court that the court can't simply rely on the blanket assertion by the state that there is no exculpatory statements made during any of these intercepted conversations. I think it's for the court to make that decision. It's for us to be able to elicit that such information by means of cross-examination and confrontation. Your Honor, but if the court rules that and prohibits us from cross-examining the witnesses concerning their knowledge, the conversations, the events surrounding the illegal intercept of the conversations at the gravesite, that would constitute a violation of the defendant's Fifth and Sixth rights under the U.S. Constitution and the 14th Amendment rights, and Article 1, Section 10 of the Texas Constitution, and specifically the right to confront and cross-examine the witnesses concerning the events surrounding the illegal intercept. Furthermore, Your Honor, it would also prevent us from going in or offering in front of the jury the testimony regarding the credibility of the witnesses, their motive and intent surrounding their investigation in this case. The court says, all right, fine. The court finds that the court holds this is improper impeachment evidence. The officer's actions do not reflect upon the officers. The officer who has testified so far, his actions do not reflect upon his character for truthfulness or untruthfulness regarding his testimony in this case. Any recordings that may have been made were not admitted as evidence, nor was there an attempt to admit them as evidence. For these reasons, I find that the potential prejudice outweighs the probative value of this evidence, and the defense is ordered not to go into it should these officers be recalled to the stand. Now, if you want a running objection on that, you may have it. Mr. John Hagler says, yes, Your Honor. Mr. Mosty says, Your Honor, we can go into, for instance, things that refute on that tape, refute the inference that the state has done. The court says there was a videotape done by Channel 5. I think everyone in the country has seen out there. Mr. Mosty says, well, you know what they didn't see was the funeral service. The state has illegally intercepted the funeral service where they stand around and pray. The state offers the silly string part of the day, and they have the prayer there where the first part of it is the prayer where they illegally intercept a prayer at a gravesite. And we can't offer that? The court says, well, I think that has already been offered. Mr. Greg Davis says, you know, Your Honor. Mr. Mosty says, we have a video of it. Mr. Greg Davis says, I don't think there is any problem with Mr. Mosty or Mr. Mulder offering that videotape. I mean, whatever was visually recorded out there, we certainly don't have a problem with them doing that. It's just the circumstances under which that was gathered. If they can show what happened out there, if they want to show that videotape. Mr. Mulder says, but we can't ask Mr. Davis says, so they have that option. And they still get to show what they feel is important for them to show to this jury. The court says, well, anyway, that is fine. If you want to do that, that will be fine. But that is the court's ruling, and the court will note your objection. You don't have to object in front of the jury for any purposes. You will have a running objection, and at 9 o'clock, we will proceed. Mr. Greg Davis says, yes, sir. Mr. Mulder says, just so I'm abundantly clear on this, are you telling me that if I recall Detective Jimmy Patterson, that I can't go into this matter at all? The court says, that's correct. Mr. Mulder says, okay. Mr. Mosty says, and we can't even go into the motive of how they conducted their investigation? It's been a central theme of this case from the beginning, is that these men went to the stage of illegal activities to try to target in on this lady. That has been the beginning of this case, and it is exactly what this case is about in its entirety, is that they never did anything other than focus on Darlie Routier, and they wanted to do it so bad that they would violate state and federal law to do so. And we are not allowed to go into that? The court says, well, the court ruling stands. Thank you. Mr. Mulder says, Judge, let me ask this just for a little direction from the court. Does the court intend to give the jury any explanation or clarification, or just let it? The court says, well, we will go over the charge at the appropriate time. I'm happy to do that. Mr. Mulder says, I mean, you don't intend to say anything to the jury. He was plucked from the witness stand rather inappropriately, and I take it the court doesn't. The court says, well, I think both sides agreed with that. I don't think he was plucked from the witness stand. Mr. Mulder says, well, he refused to answer any questions, Judge, until he had a chance to talk to his lawyer. The court says, I understand that. Mr. Mosty says, well, and then Mr. Mulder says, I understand. If I call the officers, I can't go into it. If they call them, can I go into it as impeachment? The court says, well, certainly if any door is opened, I don't think they will be calling the officer, but they very well may do it. But we want to stay out of that because I am holding that is not relevant in this particular case. Mr. Mulder says, well, I'll suggest to the court that the door is opened if they talk about any part of the investigation because this was part of the investigation. The court says, well, let's take that up at the appropriate time. Mr. Mulder says, well, Judge, it kind of depends on, it has interrupted our strategy in this case. And, I can go with it either way. I don't care what the rules are, just as long as I know what they are. If I understand what the rules are, I can play by anybody's rules. The court says, well, the rule now is this: don't go into it. Mr. Mulder says, all right, I understand that. But are they going to call? If they are going to call the officers, I will be allowed to go into it? The court says, well, anything, Mr. Mulder, that is opened up by any examination, you will be allowed to go into. That is correct. Mr. Mulder then says, well, I would suggest to the court that if they go into anything about an investigation, that this is part of the investigation. The court says, well, we'll cover that at the time that it comes. That may very well be the case. Mr. Mosty says, is the court going to allow, for instance, Mr. Frosch to get up and testify about some things and then in the middle of it prohibit or take the fifth? The court says the court is going to allow, if Mr. Frosch is called, Mr. Frosch will testify. Mr. Mosty says, pardon me? The court says if Mr. Frosch is called, he will testify. If the door is opened to anything, certainly you will be able to get into it. Mr. Mosty then says, so the court is going to let him get up and testify about some things and prohibit us from going into the full investigation. The court says we are not going to go into whatever happened at the gravesite as regards to the alleged recordings out there. Mr. Mosty says, well, what about the other officers who did it? Can we call them? The court says, we will go each one individually at the time. Mr. Mosty says, all right. The court says, anything else? Mr. Hagler says, just so I'm clear, Your Honor, you stated that, of course, we cannot question them in front of the jury, but we also are prohibited from questioning them during the hearing as to any and all statements. The court says, you may question them during the hearing. Do you want to question the officers now? Mr. Mosty says, well, one thing we want to know is we want to know everyone who was involved in this. The court says, well, can you give them that information? Mr. Mosty says, and who knew about it, participated in it, planned it? Mr. Davis says, that I don't know. I don't know those facts. Mr. Mulder says, well, maybe Mr. Davis needs a lawyer. Mr. Davis says, maybe you do. The court says, well, I doubt that. Mr. Mulder says, I've got one. The court says, I doubt that. I think both sides. All right, gentlemen, fine. Excuse me. Go ahead, Mr. Davis. Mr. Greg Davis then says, I was just going to say, in this matter, so that we can all be clear, if Mr. Mulder believes that the door has been opened, would you please instruct him to approach the bench, discuss this matter with you before he begins to go through that, quote, open door, because we both know what he is going to do here. He has done it in the past. Mr. Mulder says, Judge, I'll know when the door is open. The court says, both sides are so instructed to approach the bench before you do that if that is necessary. Mr. Mulder says, yes, sir. Mr. Greg Davis says, thank you. Yes, sir. So we won't have a repeat of what he did on Friday? Mr. Mulder says, Judge, I'll do that if it's not clear. And there wasn't anything Friday. There wasn't anything said Friday about this business. Mr. Davis says, no, I'm talking about the other agreement that we had that he broke on Friday. Mr. Mulder says there wasn't any agreement Friday, not to go into the fact that Patterson was. The court says, gentlemen, Friday has passed. Friday has passed. And what occurred, occurred. Mr. Mosty says, yeah, well, yesterday. Mr. Mulder says, well, I didn't make any agreement with them, not to mention that, Judge. The court says, all right, Mr. Mulder, fine. Mr. Mulder then says, y'all may have had an agreement among yourselves, but I wasn't a party to it. The court says, Mr. Mulder, we do not have any agreements with the court. Is that clear? Mr. Mulder says, right. Well, I wasn't a party to that agreement. I didn't have any agreement with them. The court says, we understand. Would you please modulate your voice? I can hear you. Mr. Mulder says, I understand. I didn't have any agreement with them. The only agreement I had with them was their witness would be present until, the ones under subpoena, until I agreed to excuse them, and I never made that agreement. I told them I would exercise that agreement Friday. The court says the court understands what happened last Friday, and that is over and past and done with. We're not going to discuss that. Mr. Mosty says, well, there is also, for instance, a motion in Lamine prohibiting going into breast implants that Mr. Davis went through yesterday without bothering to say, is the door open? Can I go into this? And now we're supposed to abide by these things and the state doesn't have to? The court says, no, you all abide by whatever motions are in the file. Mr. Mulder says, well, Judge, would the court address that now? The court says both sides are instructed to stay within the motions of Lamine that are in there. And Mr. Mulder then says, well, they understood that, Judge. We went into it before the court. You understood it, they understood it, but they barged right in. The court says, all right, well, the motions in Lamine, you both know what they are. Let's stay with it. If anybody does anything against it, well, let's stand up and object. There was no objection yesterday. Mr. Mosty says, well, of course not. Mr. Mulder says all that would do is call attention to it. That is why we filed the motion in Lamine, so we didn't have to object. The court says, all right. Mr. Mosty then says, and that is why Mr. Davis did it that way. The court says, gentlemen, we are here this morning on the hearing on Officer Patterson and Frosch. Mr. Mosty says, well, may I go back to my question? The court says, yes. Mr. Mosty says, I would like to know who all was involved in this. Mr. Mulder says, well, he said you can go into that. Let's call Patterson. The court says, just a minute, calm down, Mr. Mulder. I can only talk to one attorney at a time. If the state knows who was involved in it, you may please find out and please advise the defense. Mr. Davis says, yes, sir. Mr. Mosty says, may we call one of these gentlemen and find out? The court says, you may indeed. Mr. Mosty says, Mr. Patterson is under oath, isn't he? The court says he is indeed. Mr. Mosty says, may I inquire The court says, you may. Who was involved? I'll inquire. Who was involved in it? And at this point, Mr. Patterson, who is there, says, I don't want to answer that. Mr. Mulder says, Judge. The court says, well, all right. Mr. Mulder says, well, he either answers or goes to jail, doesn't he? The court says, Mr. Mulder, if I want anything from you, I will ask. Is that clear? Mr. Mulder says, well, yes, sir. The court says, thank you very much. You are refusing to answer on the grounds that it may tend to incriminate you. Is that correct? Mr. Patterson says, yes, sir. And the court says, all right, fine. So once this is over, Officer Chris Frosch is then brought in. And Mr. Mosty says, may we also identify that Mr. Frosch says the same thing? The court says, Mr. Frosch, is that your answer? Mr. Frosch says, yes, sir, it is. Mr. Mosty says, so now we can't even find out who was involved? The court says, just a minute, gentlemen. All right. The court's ruling stands as it is, as it has been expressed. And if you object to that, we will note your objection. Mr. Mosty says, no, my inquiry is, I want to know who else was involved. The state ought to know this is exculpatory evidence. This ought to be turned over. The court says, if the state knows who was involved, please inform the defense. Mr. Mosty then says, first, there ought to be an investigation going on in Dallas County as we speak about this. And the court says, well, there may very well be one, but right now we're in a trial in Kerrville. We have completed this hearing and it's 5 minutes until 9 o'clock. And at 9 o'clock, I intend to continue the cross-examination of Darlie Routier, or the examination by Mr. Davis. Mr. Mosty then says, when is the state going to give me that information? It's not going to do me much good in May. The court says, well, the state, Mr. Mosty, we understand that. Mr. Davis, should you learn the information, give it to the defense as soon as possible. Mr. Davis then says, yes, sir, I will. Mr. Mosty says, and are they under a duty to inquire? The court says, yes, they are under a duty to inquire. Mr. Mosty says, I just want to be clear, because if he never asks him, he might never know it. The court says, well, Mr. Mosty, I think that Mr. Davis and Mr. Shook and Miss Wallace will ask. All right, thank you. These proceedings are concluded. And at this point, a very short recess was taken, but then proceedings were resumed on the record and the jury is still not present. The court says, all right, let's go back on the record briefly. Mr. Hagler has a couple more objections he wants to make. Mr. Hagler then says, Your Honor, I will be very brief here with the court. Your Honor, just so that we are clear on the ruling, Your Honor, it's our understanding of the ruling that both, of course, Frosch and Patterson have invoked their Fifth Amendment privilege against self-incrimination under the Fifth Amendment. We further understand that the court's ruling that in light of that invocation of the Fifth Amendment right, that we're prohibited from inquiring from these two officers, and I assume other officers who may be involved in this intercept. As to the one, we are prohibited from cross-examining and questioning the officers regarding the intercept and all facts surrounding the intercept. The court says that's correct. Mr. Hagler continues. And furthermore, if we were given the opportunity to question the officers, we would go into matters such as the procedures utilized, who made the decision to initiate the intercept, the individuals involved in the intercept, how it was conducted, and any and all information that was learned through the intercept, including matters, not only those matters on the tape, but also matters that may have been overheard, but were not recorded by the officers. The court says, all right. Mr. Hagler continues. And furthermore, Your Honor, we would also submit that the state has made the assertion that there was no exculpatory matters on the tape. And again, we would urge that it's not for the state to make that decision. It's one that only the court can make, and the only one that we could bring to light through cross-examination and confrontation of witnesses. The court says, all right, thank you. Mr. Hagler continues. And finally, Your Honor, we would ask for a mistrial based on our lack of opportunity to cross-examine the witnesses regarding this and the fact that we cannot question Patterson regarding these matters. The court says, all right, thank you. Now, had you made those objections prior to the ruling, the court's ruling would have been the same. Regarding the motion for a mistrial, the motion for mistrial is denied. With that in mind, Mr. Greg Davis then says also, before the jury comes in, if I could inform the court that during the break, I delivered to Mr. Mulder and Mr. Mosty the names of two officers who I was informed actually did the taping. So they now have those names. Mr. Mulder says, I would like the names of the co-conspirators in the record, if we might. The court says, I think the names have been delivered, Mr. Mulder. Thank you. And that concludes the quote unquote testimony of Detective Patterson and Detective Frosch. And that's where it ends. I am going to do my best to recap this, but it's obvious that what has happened is that, we all know that the police put microphones out there at the gravesite, and they obviously evidently video recorded even from a vehicle. Um, People, both sides, the prosecution and the defense, evidently have these tapes. So that's kind of where it's at. But because what they did, according to their attorneys, there being Patterson's and Frosch's attorneys, they have suggested that they not testify to this, that they invoke their Fifth Amendment. So essentially what's happened is that even though Darlie's defense team wants to question them about this, and they bring up all kinds of really great arguments, the court refuses to allow them to do this. So they're kind of left with, here's all this information that was gathered. We can't really discuss it with the people involved because they have invoked their Fifth Amendment, and this was probably something done illegally. So let's see if I can kind of break it down a little bit. It did get really heated. I was not expecting to run into that in this testimony. I don't know why, but I just really didn't expect it to be so much back and forth. So Mr. Mulder and Mr. Mosty of Darlie's defense team, they argued that they absolutely should be able and allowed to cross-examine these officers in front of the jury. Because remember, none of this was done in front of the jury. The jury has not even been in the room at this point in time. So you know about this. It's in the trial transcripts, yes, but the jury was not present to hear any of this. So the jury knows nothing about this. So Darlie's defense attorneys believe that this recording could potentially reveal very important information about the police investigation, potentially showing that the officers improperly targeted Darlie as a suspect from the very beginning. And they suggest that the recording might contain evidence that could help prove Darlie's innocence, or at least cast doubt on the credibility of these officers' testimonies because of what they've done. And their attorneys have deemed that, hey, this is kind of sketchy. Might be a little illegal. So, don't say anything. Just invoke your Fifth Amendment. Even though a person's life is quite literally on the line. But the prosecution, of course, Mr. Greg Davis, he's the one who kind of led this whole thing, at least in this portion. He said that if the defense were to question the officers about this recording, it would be considered improper and prejudicial. And part of his reasoning is that these recordings themselves, they have not been entered as into evidence for the Darlie case by the prosecution. So it's not even there to make reference to. So what happened is all this back and forth and this argument is like, hey, the defense, really believes, hey, we need to talk to these guys. They invoke their Fifth Amendment. They try and argue that the reasons why they should be able to question these two officers, and the judge has to give his ruling. And he ultimately sides with the prosecution and tells the defense that they cannot ask the officers about this recording in front of the jury. The judge says that his ruling on this says that it outweighs any probative value that the evidence might have. And we've heard this a couple of times before, but In other words, what this means is that the judge believed that by discussing this recording, it could unfairly bias the jury against the officers and the prosecutor's case, even if it's not directly relevant to proving Darlie's guilt or innocence. So it's, oh my gosh. Sometimes I'm just shocked by what I hear in this case. The defense strongly, obviously, disagreed with this, arguing that it violates Darlie's constitutional rights to confront the witnesses against her and to present a full defense. So they go ahead and request a mistrial. But of course, the judge denies this, saying essentially to the extent that by that the trial could still continue even without having this information present, that it wouldn't somehow affect the outcome of the trial, which we will never ever know, right? So, yeah, I guess you kind of heard from Patterson and from Frosch, if anything, to say, hey, yes, we're invoking our Fifth Amendment. They didn't say anything else. That was it. A lot of this was just all of the attorneys arguing amongst each other and with the judge. And this is where it's at right now. Nothing further is going to proceed as far as these illegal recordings go right now. So, with that said, the next episode will be the rest of Darren Routier's testimony, and I look forward to going over that. And as I briefly mentioned at the beginning of this, I will have the links to Patterson's testimony in the show notes if you want to go ahead and go back and listen to what he actually had to say before he left the stand and had to go find his own attorney about these recordings. Thank you. Thank you. Thank you all for listening. You are all so, so appreciated. If you'd like to support the show, consider donating through a new platform that I'm using, Buy Me a Coffee. Here, you can get access to things not available to the general public. Your contributions help improve content, cover production costs, and bring you even more stories. The links will be available in the show notes if you want more information. And with that said, thank you for being such an amazing part of the Beach House 34 community. And I'll be back with more from Darren very soon. Bye for now.